Hello, everyone. Good afternoon or good morning for those of you out on the west side of the country. Welcome to our 5th annual Dentons Data Summit. I am delighted to see so many of you joining. For those of you who may not know me, my name is Kirsten Thompson, and I'll be your host for this event. Since our last summit, digital technologies have continued to reshape the global economy and transform the way businesses operate. No surprise there. Pace of change has been nothing short of remarkable, and it seems to be getting faster. Maybe I'm just getting older. One of the significant shifts we've witnessed is the heightened focus on privacy laws that accompany this digital acceleration. Particularly, we've seen new laws and whole new regimes in the eastern regions of the world, which we'll cover with some of our global colleagues today. Increased regulation has also meant an increase in the degree of uncertainty, particularly regarding data transfers and the complexity in complying with multiple, often competing legal regimes. In Canada, privacy laws are also evolving, and many of you have just survived or are still in the process of surviving the coming into force of the bulk of changes to Quebec's privacy laws. We've been equally busy helping organizations come up to speed with these new provisions, navigate the differences between old and new, Quebec and Canada, and so on and so forth. These changes are undoubtedly impacting all of you, as evidenced by the fact that we have over 500 registrants for this particular webinar today. Also, not forgotten completely is Bill C-27. The amendments were discussed in committee yesterday, but no actual amendments were tabled. So we had the minister speaking about that. So we know that there's an intention to put a fundamental right into the legislation somewhere. He was a little cagey on where that would be. Stricter children's privacy provisions in the draft C-27. And interoperability with the GDPR. There was also discussion about providing greater flexibility for the Privacy Commissioner to reach compliance agreements as opposed to going straight to the penalties provision. When the minister was pressed on whether the Quebec Act or PIPEDA would take precedence, he was a little cagey and just talked a lot about cooperation. No actual amendments were tabled, so 13 witness sessions that are upcoming will be on the as drafted C-27, not as the as amended. So we'll have to wait and see the amendments which were proposed to be tabled at the clause by clause review. So that's for the policy nerds in the audience. We know privacy is a key area of concern for you. We hear this from you every day. And the concerns you raise are reflected in today's webinar. And so that's what we hope you can take away from this summit is many of your concerns being addressed. I have no doubt that there will be new ones. So once again, thank you for being here today. Let's dive into the conversation. We have an exciting agenda packed with all sorts of conversations and the workshops at the end. So with that, we will move to our lightning round to get things started. We have two entries into the lightning round. First one is our Around the World review, followed by our second topic, which is the Two Truths and a Lie game. So first up is our global speakers, or are our global speakers. You'll hear from Pascal Zhang from Shanghai, China, and the developments there, Kitan Mukherjee from New Delhi, India, and Christina Park from Seoul, South Korea. Our speakers will be discussing the latest privacy developments in these countries, as well as share their insights on how organizations can navigate the privacy regulations and practices in these regimes. First up is Pascal, who will update us on the many developments in China's relatively new cybersecurity laws. According to Pascal, the hottest topic in China for cybersecurity and data protection is still the security assessment application for data export and the filing of standard contracts for export of personal information. I will now hand it over to Pascal.
Okay, thank you, Kirsten. And hi, everybody. I'm very happy to give you a quick update from China perspective. The first point I wanted to mention is that the ongoing application or SCC filing we are conducting for our multinational customers in China. And on one hand, that a lot more companies are receiving the result from the Cyberspace Administration of China for their security assessment application. And on the other hand, that a lot more multinational companies, Chinese subsidiary, are preparing and making the filing of their standard contracts for the export of personal information from China to overseas. This is ongoing works that we were doing a lot for multinational companies in China. And I wanted to remind you that the deadline of the grace period for making the filing of the standard contract is November 30 this year. If you haven't started or you had started, haven't done a lot of work, you will need to hurry up. And secondly, I wanted to share some updates about the new regulations from the Chinese government authorities. Number one will be the AIGC regulation has been published and has become effective in the August 15. And in addition to a lot of updates about regulations about AIGC in China, the one important point to know is that if that AIGC service have the attribute of a public opinions or capable of a social mobilization, the algorithm needs to make the filing with the Cyberspace Administration of China as well. And in addition to this AIGC service, and we have the updates about the MIT, about the regulation of the mobile application. In July this year, the MIT has issued the notice about making the filing for the APP, which has the attributes of doing the internet information service in China, needs to make the filing with the local bureau of the MIT, and then ultimately the filing will be centralized to the MIT. And for the existing APP in operation, the deadline for complete the filing is April next year. And for the new APP, which has not been launched to the market, you will need to make the filing first before that you can put the APP into the market. And otherwise, the APP store would likely to reject your uploading of the APP onto the APP store in China. And also, I wanted to mention that the previous catalog of the critical network equipment and specialized cybersecurity products previously issued in 2017 has now been updated. So you will need to check whether your network equipment or the cybersecurity products falls into the updated catalog. If yes, you will need to also do the security assessment or certification before that can go to the market. These are the effective and most relevant regulation. And also the Cyberspace Administration of China has published in August and drafts for comments of the rules for the compliance audit for the personal information protection, which has its basis in Article 54 of the PIPL that says about the personal information handler should regularly conduct the compliance audit for its personal information protection. And this is still a draft for comments, but it says that if you are a personal information handler handling more than 1 million people information, you will need to at least do the compliance audit once a year. And for others, at least once for 2 years. Also, the Cyberspace Administration of China has published a draft for comments about the facial recognition technologies. And among this draft legislation that talks about a lot about the use scenarios of the facial recognition technologies, such as it is prohibited in those previous space, and how you can use that in public space, in internal organization, in business places. But the one most important thing is again that if the companies using the facial recognition technology in public places, or you are storing facial information of more than 10,000 people, a filing requirement will be also applicable. Not yet effective, but it's quite likely that will become effective in the near future. And in addition to that, the National Information Security Standardization Technical Committee, the committee for formulating the national standard for cybersecurity perspective, has issued some security specification still in draft for the sensitive personal information, for the automated decision making, for the generally data security assessment. So we had a lot going on in China, and we would appreciate your attention to these updated laws, effective in process or still in drafts and comments, and to make compliance accordingly. And certainly we would be very help you on the ground if any assistance is required.
Hi everyone, I'm happy to be here and greetings from India. I'm Ketan Makhija from Dentons Link Legal, New Delhi offices, and for the next few minutes, I'll be speaking on the new Indian Digital Personal Data Protection Act 2023 that has very recently seen the light of the day. For the sake of brevity and consistency, I will be calling it the DPDP Act. So let's begin with a generic introduction about the legislation and then delve a bit deeper into certain important nuances and concepts as have been enunciated under this Act, with the underlying objective being to reinforce the right of privacy of the citizens. A quick word on the historical build-up to this Act. The Indian government has been in the process of introducing a standalone data protection legislation since 2018. The key principles that underpin the DPDP Act include the following: data minimization, lawful and fair use, purpose limitation, accuracy expectation, security expectation, storage limitation, accountability expectation. The Act finally received the presidential assent on August 11, 2023, following a unanimous acceptance by both the houses of the Indian Parliament. On the applicability of the DPDP Act, this focuses on processing of digital personal data within India, which is either collected in a digital form or in a non-digital form but subsequently digitized. Please note here that unlike the EU's GDPR, the Indian law does not apply to processing of personal data in a non-digital form and does not further bifurcate personal data into critical or sensitive data buckets. However, it's also noteworthy that consistent with the GDPR, the provisions of the DPDP Act also have an extraterritorial applicability, such that they would apply to processing of digital personal data outside the territory of India, provided that the said processing is connected with an activity related to offering of goods or services to data principals within India. Now, let's take a simple example of a Canadian online platform offering certain goods to persons in India. Whether the provisions of the DPDP Act would apply here or not. The answer is that in such a case, the Canadian platform would be considered a data fiduciary for purposes of the Indian Act and would therefore need to comply with the obligations set out therein. On the data transfer and localization aspects, a major shift from whitelisting to blacklisting has been witnessed under the new law, which essentially means that any transfer of data outside India will remain allowed unless specifically restricted. On this point, please do note that any sector-specific limitations on data transfer imposed by any other Indian regulators, be it RBI, SEBI, etc., would prevail over and supersede the provisions of the DPDP Act. Now, with respect to the consent requirement, similar to GDPR, the data fiduciaries under the DPDP Act are required to obtain an affirmative prior consent that needs to be free, unambiguous, and granular, but cannot be perpetual or irrevocable. Pertinently, the DPDP Act has imposed a retrospective applicability insofar as the personal data already in process under consent and obtained prior to the commencement of the Act is concerned. A proper notice in the prescribed requisite manner must be given as soon as reasonably practicable by the data fiduciary to the data principal. On this note, the DPDP Act has also introduced the concept of legitimate use, which means that the data fiduciary can now process the personal data of a data principal without obtaining a consent for legitimate uses, as defined under the Act. Strikingly, when compared to GDPR, the DPDP Act excludes or carves out the processing of personal data necessary for performance of a contract to which the data principal is a party from the purview of such definition. Moving on, and with respect to the obligations of data fiduciaries and data processors, the same can be broadly classified into three buckets: general, positive, and negative obligations. Accordingly, a data fiduciary would then primarily be responsible for compliance with the said obligations under the DPDP Act, breach of which would entail severe consequences by the Data Protection Board of India. In this regard, it is important to note that significant data fiduciaries, that is to say, a class of data fiduciaries to be identified by the Indian government under the rules if they handle high or heavy volumes or sensitivity of personal data or impact the sovereignty or public order of India, etc., those have been made subject to certain incremental obligations, such as appointing a data protection officer, an independent data auditor, conducting periodic audits, and data protection impact assessments, among others. As a natural consequence of which, it is expected that a considerable investment in terms of cost of compliance may need to be invested by the data fiduciaries. Now, even as the DPDP Act is yet to come into force, which is currently expected to happen in a staggered manner for different sets of provisions under the Act, it is advisable, especially for data fiduciaries, to gear up and prepare themselves for the upcoming changes. A few preparatory steps could include the following: to look closely at the company's data processing frameworks in order to evaluate the nature of data sets collected, means and types of processing, the manner of its collection, the scope of the consent forms, the data storage and retention protocols, data transfer mechanics, and ensure to align these mechanisms with the requirements under the DPDP Act. Next could be the establishment of reporting standards, management of and response to security incidents, timely handling of data principal requests, coupled with efficient grievance redressal procedures. The others may include having tools for timely erasure of data, conduct of impact assessment audits, and several other measures. Finally, given the substantial repercussions and implications of non-compliance, including significant fines and operational disruptions, it remains critical and crucial to prioritize and dedicate proper efforts to ensure compliance under the new Indian law. Thank you.
Hello, everyone, and thank you for having me today. My name is Christina Jiwon Park, a senior attorney at Dentons, Korea. Today, I would like to give you a short overview of Korean data privacy legal regime, a brief introduction of a recent case of PIPC on Google and Meta, and lastly, the recent development of Personal Information Protection Act of Korea. There are many big and important Canadian companies actively engaged in businesses in Korea, such as airline companies or global hotel chains. The Korean data privacy regime is based on consent of data subjects. Unlike GDPR, Korean Data Privacy Act is silent as to its extraterritoriality, and the general idea is that it does not purport to have an extraterritorial effect. The most notable news in past 1 year would be the PIPC decision to give penalty for Google and Meta's data collection activities. September 2022, Korean Personal Information Protection Commission made a decision to issue a penalty of 100 billion Korean won to Meta and Google. This amount is equivalent to 101 million Canadian dollars, applying the current rate of today. This is the largest penalty in Korea since the enactment of PIPA in the year of 2011. Also, it is the first sanction on the collection and use of information collected based on the behaviors of online platform users. In reviewing the case, the Commission compared the consent process of Google service in EU and Korea. In EU, the users were guided to a web page with 3 options to decide on the level of its data provision, and none of the options were pre-selected. The same web page also shows that the users may withdraw the consent or manage the consent level later. On the other hand, Korean users were channeled through a screen with simple question, I save my activities or I do not save my activities. Also, I save my activities option was already selected on the screen, and the withdrawal rights was not notified on the same page. For Meta, it was accused for not getting legitimate consent from the users. When getting the consent of behavior information necessary to show customized advertisement, it showed only top 4 lines when the complete consent message was 700 lines in a tiny scroll down box. Both of the companies challenges the decision of the Commission. The lawsuits are pending on the court of first instance. It is expected that the litigation shall take at least 3 years. PIPA's most recent amendment is effective as of 15th of September 2023, and there are a few notable changes. First, it eased the requirements for the information to be transferred to overseas. In the past, it was only possible with consent, but now there are additional cases such as where it is required to transfer the data to perform the contract entered into the data subject, or where the recipient received the data protection certificate, to name a few. As to the penalty of the data breach, in the previous regime, the financial penalty was 3% of the related revenue of the breaching party. But the changed formula states that the penalty amount is 3% of the total revenue of the breaching party. On the other hand, PIPA now deleted a few breaching items that was subject to the criminal penalty. Thank you for the listening.
Thank you to my international colleagues for giving us an overview of those key jurisdictions. There's things going on in other parts of the world, but those are the ones we selected just because of the significance and recency of those developments. You'll see that there's certain common themes emerging globally, and these are very good examples of the things that we see internationally as well as what we see in Canada. On to part 2 of our lightning round. This is new this year. This is the part where you get to wake up and clutch your coffee, be on the edge of your seat. This is 2 truths and a lie about privacy. This is interactive. You actually get to answer questions. We have 4 folks from our offices participating in this. We have Rachel Macklin from Edmonton, Malika Mustaufi, who some of you have met on our monthly webinar. She's from Calgary. We have Anna Corey, who just joined us. She's in Toronto, and Jen Reese-Jones, who's going to be leading the whole thing here in Toronto. So over to you, Jen.
Thanks, Kirsten, and welcome everyone to the first time that we're trying this new introduction of 2 truths and a lie. So essentially what will happen is through the polling function, you will see 3 statements, and it will be your job to identify which one is the lie. We thought this would be a fun opportunity to share some of the sometimes misunderstandings in terms of some of the legal requirements that we're seeing in our practice, or also just share some interesting takeaways in terms of some of the privacy developments. So with that, I'm going to start us off with the first question. This one relates to the commissioner's priorities. You have to pick which one is the lie. Option A, the Federal Privacy Commissioner, or the OPC, has most recently indicated that it will be prioritizing staying ahead of the Internet of Things. B, the OPC has recently said it's interested in dark patterns, which can be used to nudge us to reveal personal information. Or C, the OPC recently indicated that protecting children's privacy is one of its top priorities. So you can interact with the poll now and indicate which one is the lie. And while we wait for those answers to come in, I'll just say generally, it's worthwhile to be aware of the commissioner's priorities because they do influence where they put their sort of discretionary resources or discretionary activities. And that can be quite a lot that can be captured there. That could include educational activities, but also those all-important policy interpretation, guidance documents, and even enforcement because of the commissioner's ability to initiate investigations. Most people guessed it correctly. A is the lie. So Internet of Things is pretty ubiquitous now, so it's not explicitly called out as an area of priority for the commissioner. I will just indicate two things that are sort of interesting here. So in the OPC's most recent annual report that was just tabled recently, they indicated 3 areas of their priorities. So one was in fact related to AI. Another was protecting children's privacy. And the third sort of specific or explicit priority for the OPC relates to preparing for potential law reform should C-27 advance. The other option that I included there related to dark patterns. So this one actually comes from the OPC's contributions program. So every year the OPC funds different independent research projects, but when they put out the call for proposals, it's always interesting to note what subjects they are really interested in seeing research proposals on. And this year that included issues along the lines of, yet again, AI, also dark patterns and facial recognition. So with that, I will hand it over to Rachel to move on to our second question.
Thanks, Jen. So question number 2 relates to the protection of personal information. So which one is the lie here? A, organizations can use personal information for commercial purposes from an individual's public social media site, but only if the site provides users with privacy controls. B, organizations can freely use my name, title, and contact information on the Dentons website to contact me in order to sell me law-related services and products. Or C, organizations can't use the personal information in public court records or documents for commercial purposes. So I'll give you around 20 to 30 seconds to vote on the poll, and then we'll discuss the lie. There we go. Okay, perfect. So A is the lie. A is the lie, but C is sort of a lie, sort of true. With respect to A, the Privacy Commissioner has found that scraping images from the internet amounts to mass surveillance and violates Canadians' privacy rights. Additionally, according to the Privacy Commissioner, social media companies are on the hook when it comes to data protection and privacy laws. Even if an individual's personal information is out there in the public domain, these companies are still obligated to safeguard it from any unauthorized scraping. With respect to C, organizations could potentially use the personal information in a public court record or a document for commercial purposes, but only if those commercial purposes are related directly to the purpose for which the information appears in the record or document. So, for example, a lawyer could use it to try and pitch their legal services, but Widget Co. could not use it to try and sell the person widgets. On to Malika for question number 3.
Perfect. Thank you, Rachel. And if we could have question number 3 there, we'll be discussing some safeguards and security breaches. A, the federal legislation PIPEDA requires safeguards to be appropriate to both the sensitivity and the volume of the personal information. B, paper records with personal information must be protected with the same rigor as electronic records. And C, an employee who has authorized access to personal information, but then abuses their access to misuse that information commits a breach of security safeguards under PIPEDA. So you can go ahead and put in your vote. And as you can see, this question includes both the principles of the protection of your personal information with reasonable security safeguards, and also what causes a breach of those security safeguards. Could we have the answer, please? Okay, all spread out. So actually, the third one is the lie. PIPEDA requires safeguards to be appropriate to sensitivity and volume. But the third one, when an employee has unauthorized authorized access, but abuses their access to uses, that is not a breach of security safeguards. And that's just by the definition that's put under the federal legislation. So a breach of security safeguards is defined as the loss of unauthorized access or unauthorized disclosure of personal information that results from a breach of your security safeguards. So you can see that unauthorized use, which is the misuse of the employee, is not within that definition. And so while that is the case, organizations do have the obligation to protect against misuse of their employees. However, it's only that it would not be a breach of security safeguards under that legislation when there is an unauthorized use of employee. So it's important to keep that distinction. And I'll give it back to Anna.
Perfect. So this is about the application of PIPEDA or private sector privacy laws in general to charities. A, charities and not-for-profit organizations are subject to Canada's private sector privacy laws. B, a charity or not-for-profit organization that trades donor lists but doesn't sell them can rely on implied or opt-out consent to do so. And C, Alberta's private sector privacy law has special rules for not-for-profit organizations. I'm just going to give everyone 20-30 seconds just to give their answer here. This is an area that's often confusing for charities. Laws can, of course, be different across the country. So I'm curious to see what everyone puts here. Okay, so everyone got that right. B is the lie. There was a recent finding of the OPC that a charity or not-for-profit organization needs opt-in consent or explicit consent in order to trade donor lists. Of course, PIPEDA applies to commercial activity and it's not based on the type of organization, but there has been confusion in the past about how this applied to donor lists specifically. But commercial activity is defined to include this type of bartering or trading. So everyone got that right. I'm going to pass it back to Jen.
Okay, so I think we have time to fit in one final polling question if we can pull it up. Let's get on the responses quickly here because we're just going to squeeze this one in. Okay, so which one is the lie? A, access requests for personal information represented the largest percentage of PIPEDA complaint types investigated in 2022-2023. B, under PIPEDA, an organization must respond to an access request within 30 days of receiving the request, or seek a 30-day time extension if it's which is available for specified reasons. Or C, a partial response within 30 days is considered by the OPC as sufficient to meet the 30-day time requirements as long as you have most of it. So I'll just give you about 10 seconds to submit your response. While I indicate there, I will just mention that the statistics in terms of the OPC investigations and where they're putting their resources for enforcement are available every year in the annual report that they publish, often in sort of tables at the back end. And they give a really good indication of where the sort of enforcement or compliance activities are taking place. So that may have given away the response a little bit. Let's move to the responses, please. Oh, interesting. So almost no one thought this was the case, but A is actually true. So the lie there was C. So the partial response isn't actually considered to be sufficient according to interpretation bulletin posted on the OPC's website. So it's really important there. Actually, there was about 93 out of 380 of the OPC's investigations last year related to access requests, and another 55 related to time limits, which I'm assuming is the sort of 30-day time limit. So it shows just how many of these the OPC is dealing with, and an easy sort of area for organizations to focus their compliance efforts to make sure they're getting the responses in within that 30-day time frame under PIPEDA. So we hope you've enjoyed the 2 truths and a lie game, and now I'll pass it back over to Kirsten.
Thanks, Jen. Thanks, the rest of my colleagues. That was a lot of fun. We have about 10 more questions we didn't have a chance to get to, so maybe we'll do another two truths and a lie. I certainly learned something there, and I see we had a couple of questions quarreling with us. This is why I love presenting to lawyers. They always have something to share. We'll look into these things. If you think we got something wrong, please let us know. We'll update and upgrade for our next round of this. Now we move on to, we've been discussing regulations primarily, but let's move on to the other side of the privacy coin, which is the common law litigation side of things. And our speakers are Kelly Osaka, a partner in our Calgary office, and Chloe Snyder, a partner in the Toronto office, and they'll be updating you on litigation matters.
Hi, everyone. Thank you for joining us. We don't have a game for you. Perhaps us litigators are more serious and less fun. We want to cover 5 broad themes that we see as trends in privacy class action litigation. So the first is certification and themes around that. The second is settlements. The third is merits decisions. The fourth is vicarious liability. And the fifth is cases around lack of consent as opposed to data breaches and what the future of privacy class actions might look like. So if we could move to the next slide, I'll jump in with the first trend, which is certification. And I'd say that this trend is really that there is a chill on certification of privacy class actions, certainly as they relate to data breach cases. And so what we've seen in the last year or so is various courts across Canada, including appellate courts from Ontario and Alberta, really taking a hard look at intrusion upon seclusion and other related allegations connected with privacy breaches. So the first is a trilogy of cases that was released late last year, all of which involve what we call database defendants. So defendants that have collected and are storing usually customer information, and they then become the subject of a third-party hack. And in all of these cases that went up together to the Court of Appeal, that's the Equifax, Marriott, and TransUnion cases, the Court of Appeal denied certification of the intrusion upon seclusion cases on the basis that it was not the defendants in those cases that had done the intrusion. It was a third-party hacker, and the intrusion upon seclusion tort that was first recognized in 2012 in Ontario doesn't cover cases where the defendant was also the victim of the breach. Now, I'll say this is I think a helpful case from a defense perspective at showing that the intrusion upon seclusion tort can't be used where the defendant is actually the victim too. But there are 2 caveats to this. The first is that these cases didn't deal with issues relating to vicarious liability, and I was interested by one of the 2 truths and a lie about when an employee gains access to information, but then misuses information to which they have lawful access. And I think that that's still an area where our courts haven't weighed in on vicarious liability about that, although my colleague Kelly will be getting to that. But that's not what these cases cover. These cases are about third-party breaches. The second thing that these cases don't deal with is negligence. So they were really focused on the intrusion upon seclusion tort, but I still think that's significant because in intrusion upon seclusion, you don't need to establish compensable damages. You can be awarded moral damages, whereas in a negligence case, you need to establish some compensable harm. So it's a much more of an uphill battle for the plaintiff's bar than if you can just get moral damages of a small amount for a large class. So these cases are very significant, and I think have put a chill on starting data breach based class actions. The second important decision is the Setaguchi case, which is from the Alberta Court of Appeal. And that was also a third-party hacking case that was focused in negligence. And the Alberta Court of Appeal in that case found that the pleading didn't disclose a cause of action in negligence because the harm that was alleged was, they called it the inherent value, I am using air quotes, of privacy, and that that the court said that the idea that your inherent value of privacy is somehow a compensable harm without something like identity theft had quote no hope of success at trial. So we see again the court there taking a very hard look at these cases, and the same is true also in the Stewart and Dem case in terms of what type of access to information is properly the subject of one of these privacy class actions. In that case, a nurse had used patient information to obtain drugs that were otherwise supposed to be for the patients. And the divisional court in this case found that the access to the information for the purpose of some other for some other reason, which was to get drugs, was too fleeting and did not give rise to an intrusion upon seclusion. So we can see a chill on certification here. If we can then go to the next slide, our next observation is about settlements. And in the settlement approval hearing in the Yahoo decision, Justice Perel went through a series of recent settlements in the privacy class action context and noted that the dollar value per capita of these class action settlements is very, very small. We're talking generally $1 to $5 per class member. And certainly our own research of this area is consistent with Justice Perel's observations. And in fact, there have been many, many decisions since the settlement approval in the Yahoo case that continue to corroborate this. Obviously, there are exceptions where highly sensitive information is an issue, whether it's credit card information or sensitive health information, but otherwise we're seeing very low dollar value settlements per class member. And then the last theme that I'll deal with is decisions on the merits. So for a long time, all we had were certification decisions in the class action context without decisions on the merits. But in the last year or so, we've seen a number of decisions on the merits, two of which are up on screen now, where in some cases, like in Lamoureux, the court has dismissed the action, in that case on the basis of a failure to establish compensable harm. Getting back to the theme we started with about what is actually damages for a privacy breach. And in this case, the court found that your regular stress and frustration of your information being out there was not enough, and that there was no causation established with respect to the plaintiffs who had, or the class members who had complained about identity theft. Conversely, in the Duez case, the court did find that there was liability for misuse of information without consent, which my colleague Kelly will get into. That case is actually going to a 4-week damages hearing in November and December, which I think shows, again, some of the complications around damages in this area. And with that, I'll pass it over to Kelly to finish up on our trends.
Thanks, Chloe. Yeah, I'll pick up where you left off there and speak first to the vicarious liability trend. The case that I'm looking at is RE versus ICBC, which is the compulsory vehicle insurer plan in British Columbia. This is a merits-based decision that came out of the BC Supreme Court, and that's simply due to the fact that the BC embraces the summary trial procedure, so you are more likely to get to a merits-based decision in that province. And here the court found basically that ICBC was vicariously liable for the acts of a rogue employee who accessed personal information of ICBC's consumers and sold that information to a criminal organization. And looking at the vicarious liability issue, the court found that the employee's disclosure was directly connected to her employment, including the fact that ICBC had granted her access to the database with the class members' personal information. The court found that there was no need for ICBC to have foreseen this specific wrong so that she would sell this information to a criminal organization in order for vicarious liability to be imposed. It was simply sufficient that ICBC knew that the information was accessible by the employee and was vulnerable to abuse. So the takeaway for organizations is that it should obviously limit access of employees to personal information on a needs-to-know basis, and also to enforce standardized penalties if employees' breach is found. So moving away from vicarious liability and away from breaches in general and on to this other trend of consent that we're starting to see in both regulatory investigations as well as class action proceedings. And I'm sure many of you are familiar with the complaint brought to the OPC under PEPITA for an investigation into a home hardware retailer that was summarizing purchases and providing that to a third party without knowledge or consent. The purpose of the disclosure was to measure the effectiveness of social media advertisements. The OPC, in concluding the investigation, found that the retailer's privacy statements were not sufficient to obtain implied consent for disclosure, and that they had failed to provide a clear explanation of the use and disclosure of this non-sensitive personal information. So basically, the retailer should have obtained express consent in order to make use of the personal information in that way. And this is another case where we see a regulatory investigation leading to litigation risk, including class action brought by Mr. Merchant in Saskatchewan, as well as another class action brought in Quebec. And just to finish up on this consent piece, I'll go back to the Duez case that Chloe mentioned earlier, which was a merits-based decision in front of the British Columbia Supreme Court. Again, using that summary trial procedure, which gets them to a merits decision so much quicker than in other provinces. Just highlight from the summary trial decision that the court there found that the onus was on the social media company defendant to prove consent as it was best suited to do so. And the court there also looked at the terms of use that would reasonably be read to include control by the user of their name and image. However, the evidence established that they could not in fact control the use of that information. Again, the court concluded that express consent was required. So the takeaway here on consent is that organizations should consider, if they are entering into a social media campaign, an advertising campaign, whether express consent is necessary. And I'd add to that, they should also take into account the jurisdictions in which the campaign will be operative and whether there may be any privacy compliance issues that might arise. So I'll pass it back to Kirsten. Thank you.
Thank you both for that. That's a very concise summary. Obviously, if you need to know more about that, please reach out to Kelly or Chloe. They can go into great detail about where things are going and what directions they're heading and how much exposure you might have. The law is changing in this respect quite quickly. Now you get to hear from me. We're moving on to penalties, fines, AMPs, all those good things. What happens when things go wrong? All right. So as many of you know, there are new enforcement powers and provisions in both C-27 and in the Quebec Act. So we're going to talk a little bit about what that means, how this is all supposed to work, and what you can do to, if you get it wrong, how you can try and keep fines, penalties, etc. to a minimum. So what we're going to talk about is the penalty provisions in the Quebec Act specifically, and a little bit about the difference between penalties and fines and why that matters. We're going to talk about which violations attract one or the other and why. And then we're going to go into a deep dive about the framework for the penalties and the framework for the fines and when the CAI, which is the Quebec regulator, chooses one over the other. Finally, there is this thing called an undertaking, which might get you out of having to pay some money, but probably not. And then we'll talk about reducing your risk. So what are the penalty provisions in the Quebec Act? Well, there's actually three different types. So in the Private Sector Act, and we're only going to talk about the Private Sector Act in Quebec right now, there's administrative monetary penalties, which the cool kids call AMPs or MAPs if you're in Quebec, penal offenses, which sounds very scary, and they are, which I refer to as fines or penal proceedings here, and a private right of action, which is punitive damages. We're not really going to go much into that this time round. So the AMPs regime is administered by the privacy regulator, the CAI in Quebec. It's not actually the CAI, it's somebody designated by the CAI. And this is to sort of keep a separation from the investigator and the enforcer. The thing that caught everybody's attention, of course, is the great big number that's attached to that. And the fines or the penalties, pardon me, are up to 10 million or 2% of the worldwide turnover. Fines, even bigger number attached to that, 25 million or 4% of the world turnover. And if you're in that territory, these are imposed by the court of Quebec. So you're in a slightly different regime there. And then just for fun, there's the private right of action whereby individuals can actually sue you. All right, on to AMPs. So what is a AMP? It's really the penalty part that you need to understand. This is a civil penalty and it's imposed by a regulator or something similar. And it's for a contravention of the act. In this case, it's the act. It could also be a regulation or a bylaw. Many, many different regimes have these. The idea is to sort of keep all of this stuff out of the courts. That's fine when it's a $25 penalty or a $30 penalty. When you start getting penalties up into the millions, it becomes a whole different ballgame. One of the things about penalties is once an AMP is levied, it becomes due and payable. It's basically you break the rule, here's your bill. You do have some sort of limited rights of review that might be available, but often people are surprised that right out of the gate, they get handed this bill. It's sort of counterintuitive to those of us that regularly are at home in the courts. It's a very different regime. It's important to note that this is regulatory in nature and it is not criminal. So the idea is that they want you to play nice. They're not being punished. And that's critical because the minute something becomes a punishment, you get all the Section 11 charter rights. That's the right to be presumed innocent, the right to be informed of the case against you, et cetera, et cetera. None of that attaches in a AMPS regime. You do, however, get the right of judicial review. So if you think if you've been unjustly or unfairly treated, you can pursue a judicial review route. Unfortunately, the Administrative Tribunal in Quebec also recognized that a person can basically bring forward a due diligence defense once you get dinged with an AMP. So that will be important if you do, in fact, get one of those bills. Then we get on to fines. So this is the other side of the regime. This is a little different. This, you need a conviction first, and then you get handed the bill. This requires that you plead or be found guilty in a court proceeding. Hence, this is we're in the court. This is punitive. So it does trigger those charter rights because it is intended to punish you. And as I mentioned, sometimes penalties can be high. If the penalties are high, that alone will not make them punitive, but a high penalty along with some other indicia can transform an AMP into a fine. That's rare. It does happen, and there's a leading Supreme Court case on that. So just because you are shocked at the amount of penalty that has been levied against you, that will not give you the right to necessarily use those standard charter rights that you would think would normally attach. So it's, again, a very different regime. All right, so what attracts what? Here's a summary. I won't go into all of them. I have highlighted in red the triple jeopardy categories. So if you get those ones wrong, you could be on the hook for AMPs, fines, and punitive damages. So those of you that are in charge of compliance or the privacy functions in your respective companies may want to pay close attention to that. They're pretty ordinary things. For instance, if you violate the act by collecting, using, disclosing, retaining, or destroying personal information in ways other than sanctioned in the act, you could be liable for one of those three categories. Similarly, if you don't take appropriate security measures to protect that personal information, again, you've got the triple jeopardy. If you mishandled your breach by not reporting it or notifying people, once again, you're on the hook across the board. And then there's some other ones. Some of these are obvious, not surprisingly, that fines are levied if you fail to comply or you obstruct. That's pretty typical for a regulatory type regime. If you meddle in an investigation, that kind of thing. So if you do get investigated, play nice. Interestingly, there's both an individual right to sue and the fine for attempting to re-identify de-identified or anonymized information. All right, so what's the framework? One of the things the CHI is required to do under the Act is to put together a general framework, and that is what they did. The framework is supposed to address those four things. What are the objectives? What are the criteria? When will they choose the criminal remedy as opposed to the AMPS remedy? And what else can they do besides imposing the sanctions? And so based on that those foregoing four criteria, the CHI indicated it would seek two objectives when it imposes AMPS. One, make sure you fix it fast. So encouraging you to take rapid corrective measures, and dissuade recidivism. In other words, it's going to be too expensive to continue doing what you're doing. Then we get into the process, and I've summarized the process here. So if you are going cheerfully about your business, and then one day you receive a notice of compliance, your world is about to get a whole lot darker. So first thing the CHI will do is issue a notice of compliance. This tells you what their view is, what has gone wrong, and you need to take remedial action immediately. You do get to say, but no, we didn't get this wrong. This is why this all works for us. And there can be a back and forth, but the goal here, the CHI here, is that you fix whatever it is that they have decided is not in compliance with the Act. Interestingly, there's no timelines provided before the CHI can issue a notice of claim, which is the next step. So I would expect that the CHI, in an egregious case where it doesn't get a response from an organization, would probably move faster to the notice of claim. Where you think you've got it right and there's a big misunderstanding, or where you have rapidly moved to fix something, there may well be a little bit more back and forth between they move to a notice of claim. So the notice of claim, which is the next step, is actually what imposes the AMP. So you get this notice of claim. You are now the person in default. So the person in default, you have a right to request a review of the decision, and you have a right to request that review within the 30 days. So this notice of claim is the one that has the big number on it. That will tell you what you owe and why, and what the violations were. If you don't like that, you can then review that decision, and then you're into that third box on the right there. The reviewing decision here, it could confirm it, it could reverse it, or it could modify the decision in the notice of claim. And you, the person in default, you have the right to contest that decision in the Court of Quebec. So now you're into the court process. And again, you have 30 days from the notification of the review decision to do that. And there's a note at the bottom here. Note that the CHI has 2 years from the date of that violation to impose any AMPs on you. That's quite a long time. Most violations will be an ongoing type of violation, but it's possible you could have done something 2 years or 1 year and 364 days previously, and then find yourself on the hook for an AMP. So how does the CHI figure this out? Well, they go through a couple of steps, but first they have to figure out whether to impose the sanction. And this is the criteria they look at. And there's a theme here. There's different stages that are coming up where they they consider various criteria. And a lot of these criteria are quite repetitive. So not surprisingly, in deciding whether to impose a sanction, they're going to look at the nature, seriousness, repetitiveness, and duration. How bad was it? What was involved? Did you do it over and over again? And did you do it? How long did you do it? Sensitivity to personal information is going to be a factor. There's a difference between moving, say, an email address and, I don't know, facial biometrics. How big is the problem? Everybody, millions and millions, or a few? And was there a risk of serious harm? When you got, once you figured out something went wrong, how fast did you fix it, and how completely did you fix it? Did you play nice with the CHI, or did you drag your feet and refuse to answer the questions? Interestingly, I found this one very interesting, is did you offer compensation to the people affected by the violation? I'm curious to see how that one pays out. This could become extortionist in certain cases. And the ability to pay. So if you are big and have lots of money, your penalty is probably going to be a little higher than if you are small and don't. This in other regimes where I have had experience, they will ask you for balance sheets, P&L, audited financial statements, those kinds of things. So that's whether, but how do they get to the amount? So they do a two-step process here. First, they categorize the breach or the violation. And again, there's some more criteria. They look at the nature, the seriousness, the repetitive nature, and the duration, how sensitive the information was, the number affected, and the risk of serious harm. So that will get you to a category. And here are the categories. So you're a category A, B, C, or D person. A are minor ones. D, very serious. See what they've said. There's the integrity of the protection of personal information, the apprehended consequence. It's major, it's real, irreparable. So those are the big bad ones. That gives you a base amount where the penalties start, and that the base amount is smaller if you are an individual versus an organization. Once they've established the base amount, they then go to step 2, which is the aggravating and mitigating factors. In other words, this is the dial that moves the numbers up or down. Again, different criteria here. So repetitive, duration, sensitivity, number of people, the risk of serious harm. What did you do to fix the violation and address the consequences? Again, the cooperation piece, any compensation you offered, and how much you can afford to pay. So that will dial it up or down. That's the AMPS side of things. So when will the CHI consider the criminal side of things? These are those penal consequences. So not surprisingly, these are generally only for very serious offenses, particularly where there's evidence of significant damage having already occurred, or whether there's a high risk of significant damage to the privacy of the people, to vulnerable customs or persons, and in light of the sensitivity of the personal information concerned. So if you are a company that handles the information of vulnerable customers or persons, think senior citizens, children, you are already at a higher risk for fines than, say, a general retailer or something like that. The CHI will not fool around. If you do not play nice or fail to comply with an order of the CHI, they will be more inclined to move the criminal route. If you don't take adequate measures, in other words, you've figured out what the risk is or the violation is, but you only put half measures in or didn't fully solve the problem, you can expect the CHI may move towards the criminal side of things. If in violating the act, you were intentional about it, if you were negligent or reckless, again, we're moving more towards the criminal side of thing. If you obstructed, if you provided false or inaccurate information. So pay attention to that one. There is often an urge to respond quickly to an investigation and provide information. Make sure it is right. Really pressure test the quality of the information that you are providing, because it's not hard to provide inaccurate information accidentally. Failed to provide the information required is also another one that will get you in trouble. And again, ongoing breaches of violations. If you are a frequent flyer in this regime, eventually they're going to lose patience with you and move you over to the criminal side of things. Here you will know you're in trouble if you receive a statement of offense. Then we get on to sentencing. So again, this dials it up and down. Similar, very similar criteria here: nature, gravity, repetitive nature, and duration, sensitivity, whether it was intentional or negligent or reckless, foreseeability of the violation. Should you have known better? Were you warned about it? If you have 15 complaints in your privacy inbox saying this was a problem and you didn't do it, they're not going to be very forgiving. Did you try and hide the problem? Did you fail to mitigate the problem? Did you fail to take reasonable steps to prevent it happening in the first place? This next one is, did you benefit from failing to take measures? In other words, did it increase your revenue, or were you able to dramatically reduce expenses? And so this is the I can't afford it defense is not going to be much of a defense here. If I can't afford it, left customer information or personal information exposed, this will probably be a factor in the sentencing. And then the number of persons affected and the risk of harm. And it gets progressively harder as you go along. For instance, if you are a first-time offender, you're going to get dinged, but you will get dinged doubly so if it is a subsequent offense. Again, a note here, the CHI has 5 years in this case from the commission of the offense to initiate criminal proceedings. And then always my favorite, and this is the one that gets everybody sitting up and pay attention, is that directors and officers can be found guilty under this regime. I mentioned undertakings. So undertakings are things where you agree with the CHI about what's going to happen. These are only available for AMPs. So this is another reason why you might want to keep it in the AMPs side of the regime as opposed to the fines side of the regime. It's also available for the punitive damages, the private right of action, but we're not going to discuss how this works. So an undertaking is essentially the CHI says, here's all the things we want you to do. You say, yes, yes, this is what we will do, and you undertake to do them. The benefit of that is that it generally cuts short the AMPS process. So what the undertaking does, you agree that here are the acts and omissions that you did, and the provisions of the legislation that were violated. The undertaking will include conditions that the CHI deems necessary to include. So there'll be a whole long string of conditions. You have to get an audit. You have to periodically review this. You have to get a third party in there. You have to hand over all of your policy documents in a certain period of time. Those obligations or conditions can also include paying a sum of money. So you still might get a hit to the wallet. It's up to the CHI to accept or reject that undertaking. So just because you agree you want to enter into it doesn't mean it's going to happen. So once the undertaking is accepted and complied with, then you don't get subject to the AMPS with respect to those acts or omissions. And so there's a pros and cons chart here. So just because you use the undertakings doesn't mean you won't necessarily have to pay. You might not have to pay an AMP, but you could end up still having to pay some sort of sum of money. The good news is that there's no AMPs for the violations that are set out in the undertaking, but you could still be subject to AMPs for anything that's not within the scope. So the key of negotiating these undertakings is to make sure you've got as much as possible caught within that. It could be that when you enter into an undertaking, it ends the matter, but more likely there will be a term of ongoing supervision. So unless you are real friends with CHI, you can expect them to be hanging out with you for probably anywhere from 6 months to a year and poking their nose into your business. That is a deal breaker for a lot of companies. They'd rather just take the penalty and go. Others don't see that being a problem. And then it's an open question about whether or not entering into an undertaking could thwart punitive damages. Again, that's beyond the scope of what we're going to talk to today, but just park that in the back of your brain. It could be something handy if you find yourself facing a class action. So reducing your risk, the things you need to do, first one should be obvious, but surprisingly, it is not as obvious as you think. Comply. Figure out what the act requires and do it, particularly in those things that are listed as being violations. If you can't do all of them, then I would highly recommend that you look at those triple jeopardy categories I mentioned and make sure your house is in order in that respect. And I've listed those ones there. These should be part of any really robust privacy program in any event. But having these ones absolutely nailed will help you avoid those triple jeopardy categories. Another way to limit your risk here and supported diligence defense is reduce the personal information you have. If you don't need it, if it is not necessary, why on earth do you have it? Particularly sensitive information. There is really no merit in keeping information around. I know that traditionally there's been a cost to get rid of information and no cost to just keep it piling up either in boxes or on servers somewhere or memory. There's now a cost, a pretty significant one, to keeping that lying around. You're exposing the organization to a fair bit of risk that's really quite unnecessary. The other one, review your processes. Privacy programs is not a one and done thing. An annual review is warranted, probably a little more frequently, and do it self-audit or have an outside party audit. And here's the pro tip. If you're going to have an outside party audit you may want to use a lawyer or law firm to do that, because if you do an audit and all sorts of bad things are uncovered, you've now generated evidence against yourself, unless it's in the context of some legal advice. That evidence that you've generated against yourself may be something that the CHI decides to request or a litigant decides to request from you in the discovery context. Finally, and this is a big one, actively monitor your privacy inbox to fix things. I can't tell you the number of times where we're ended up in front of a privacy regulator because somebody got so frustrated sending endless emails into an inbox and never got a response. They finally escalated to a privacy commissioner. Your privacy inbox is more than just an inbox for complaints. It will tell you, it's an early warning system. If you are getting the same complaints over and over and over again, that is one of those things that will go into those sentencing factors we talked about a little earlier, about. Did you know about this, and did you take steps to fix the problem? That foreseeability piece. And that covers our quick detour through penalties and enforcement and AMPs and all of those good things. And with that, we are going to move on to our next speaker. We are covering off, this is a perennial favorite, vendor service agreements. This is a perennial favorite, likely because they are a perennial pain in the butt. Those of you that deal with these things will understand that. Most of you probably spend a lot of your time trying to convince your organizations that this is really, really important. You are proving to be right about that. In fact, you were right all along, but now you are being backed by the penalties, AMPs, and other provisions. You were right. With the significance of the fines and penalties regime in Quebec and pending in the rest of Canada, it is really important that you get the data provisions right. I can tell you right now, I have 7 different agreements on my desk for a variety of transactions, and 4 of the negotiations are almost completely focused on data and privacy elements in an agreement. So with that, I will pass it over to Danielle Dudelzak in our Calgary office, who does all of this. Over to you, Danielle.
Hi, everyone. Thank you for joining me today for our conversation about vendor service agreements. I'm guessing everyone on this call is involved in an organization that in some way works with service providers in different capacities, or maybe is a provider of services themselves. So this session today will be a quick stroll through the types of things that an organization really should be thinking about and putting into their agreements with service providers, both from a current PIPEDA perspective and also reflecting some upcoming changes in federal privacy laws in the form of the Consumer Privacy Protection Act, CPPA. So the checklist that we'll go through shortly will be sent to you after this presentation. To refresh everyone's memory, the Personal Information Protection and Electronic Documents Act, PIPEDA, is Canada's private sector privacy laws. It sets out 10 principles for the collection, use, disclosure of personal information in the private sector. Principle 1 is accountability. So this is the one that we're going to focus on today. It states that an organization is responsible for personal information under its control. So according to the OPC, an accountable organization has to have policies and procedures in place that demonstrate at a minimum the capacity to comply with privacy laws. So the accountability principle is implicit in Alberta, BC, and Quebec. Interestingly, PIPEDA doesn't actually define what a service provider is, nor does it define what constitutes a service provider relationship. So what we've seen is PIPEDA's locus of control is on the organization that's responsible for information in its possession or control, which includes information that's been transferred to a third party for processing. So essentially, if you are the accountable organization, you'll need to do certain things to demonstrate that you're complying with your compliance obligations. And remember that an organization is responsible for personal information under its control, even if it's in the custody of a service provider. So it's worth mentioning that the accountability principle is also found in the CPPA. So that's that privacy law that's been advanced as part of Bill C-27 to replace PIPEDA. And thankfully, this concept is more explicitly set out. So under the proposed CPPA, an organization providing services for or on behalf of another organization to assist the organization in fulfilling its purposes would be considered a service provider. So personal information is deemed to be under the control of the organization that decides to collect it, and that is determining the purposes for its collection, use, or disclosure. So this is true of whether the information is collected, used, or disclosed by the organization itself or by a service provider. So this actually clarifies a problem that arose in PIPEDA, where we had highly integrated entities or entities working in partnership across a data supply chain. So for instance, a franchise or a dealership business model that were mutually involved in multiple steps that sometimes led to confusion about who was responsible for what. So under the proposed new language of the CPPA, the question of whether a service provider relationship exists will be answered depending on which organization ultimately makes the decision about personal information. So this new language adopts the conceptual basis of controller and processor that you might have seen under the GDPR, and agreements that kind of deal with GDPR, you'll often see the concept of a data processor and a data controller. So this will add some clarity to who the accountable organization actually is. So businesses with an established business model may actually, under the CPPA, find that the accountability for personal information has kind of been turned on its head. So for instance, in a franchise type model where personal information was collected at the franchise level and then provided to the central franchisor, accountability under PIPEDA may have well been with the franchisee. However, under the CPPA, if it's the franchisor determining how the data is collected, how it's supposed to be used, the franchisor actually might be the accountable entity, despite the actual collection occurring at the franchise level. So you can see how the new provisions of the CPPA might actually disrupt existing contractual obligations in respect of breach reporting, notification, limits of liability, indemnification procedures. So it's worth reviewing these agreements to see how that works. So just really briefly, the CPPA also expands the definition of who a service provider actually is. So in addition to a contractor or subcontractor, which would quite obviously, be within the confines of a service provider, the CPPA actually defines a service provider to include a parent corporation, a subsidiary, or an affiliate providing services for or on behalf of another organization. So businesses should be aware that the processing of personal information by a related company on its behalf, as opposed to just a vendor or a contractor, could actually amount to a service provider relationship. So what about the level of protection required? Just as a refresher, businesses are obliged to use contractual or other means to provide a comparable level of protection while the information is being processed by a third party. So according to the OPC, a comparable level of protection means that the service provider must provide protection that can be compared to the level of protection the personal information would receive if it hadn't actually been transferred. So while the privacy protection measures that are adopted by service providers don't have to be identical, the OPC currently considers that they should be generally equivalent. So it's worth noting that under the CPPA, there's a carve out from Part 1 for service providers, and the broader obligations under that part won't apply to those organizations acting within the definition of service provider, which could be welcome news. So businesses acting as a service provider should be aware that under the CPPA, any processing of personal information outside the scope of an agreement with a principal organization would likely result in the CPPA applying to them in its entirety. So under the CPPA, organizations acting as service providers will need to be really careful about how the scope of their processing activities is defined in their service contracts with principal organizations. Service providers will also need to be careful about putting in place controls internally to ensure that the information they receive is processed only within the scope agreed to. So part of what we see with data processing agreements under GDPR type arrangements, where you have a schedule at the back that lists the types of processing that is agreed to, could become useful here as a way of setting out, what the specific instructions around the scope of processing, what they are. So do we need consent to transfer personal information to a service provider? This is a question that I get asked a lot. It's an area of confusion around PIPEDA, subject to numerous OPC findings. Thankfully, the CPPA would expressly permit organizations to transfer an individual's personal information to a service provider without their knowledge or consent, subject to transparency requirements. So this is a welcome clarification. Back to the current position under PIPEDA, the OPC in a finding on this point noted that organizations transferring personal information to third-party processors should communicate clearly about this transfer to both current and potential customers. So under the CPPA, it appears this wouldn't be necessary, as the language of the CPPA doesn't require knowledge or consent. However, there is a section of the CPPA that, as currently drafted, would require an organization to make readily available information about its international or interprovincial transfers or disclosures if the transfers or disclosures would have reasonably foreseeable privacy implications. So you're still going to need to disclose what kind of transfers are taking place here. So turning to our checklist now, we have some speaking points on this topic. If that screen could please be shared. Oops. Okay, so the first consideration on the list is the sensitivity of the information that's due to be transferred to the service provider. So the OPC considers that certain types of personal information will generally be considered sensitive and require a higher degree of protection. So that includes health and financial data, ethnic, racial origins, political opinions, religious, philosophical beliefs. But we know that any information can actually be sensitive depending on the context. So this will impact the nature of consent that you will need to ensure is obtained, and also the nature of the security safeguards that will need to be put in place. So express consent must be obtained prior to collecting, using, or disclosing sensitive personal information under the CPPA. So initial conversations with the service provider should include the topic of, how and when consent from a data subject is going to be obtained, making sure that the right kind of mode of consent is obtained. So the second topic, contractual provisions, this is a big topic. There's many considerations on this list. Generally speaking, we want to be specifying the standard of care and obligation with respect to the treatment of personal information, given that, as we've been discussing, an organization will remain accountable for the personal information that is being transferred. So we assume that an organization would have done its due diligence on the service provider's privacy practices in the first instance, and would incorporate any mitigation measures into the service agreements. So whether that's additional encryption measures or adherence to your organization's information security policies. You'll also want to consider any specific legal requirements, particularly in the context of cross-border sharing of personal information. So you might need standard contractual clauses if GDPR is going to apply. You want oversight over security measures and audit rights. This is really crucial to demonstrate a service provider's compliance with the agreement and with data privacy law. This will come as no surprise, but you will often see requirements for training and education for all service provider employees with access to personal information. Equally important is specifying the return or destruction of personal information on termination and getting a certification of compliance. You don't want service providers holding on to personal information for longer than necessary to achieve the agreed purpose. And indeed, if service providers are only permitted to process personal information on the principal organization's instructions, it wouldn't be in their best interest to be holding on to this either. Privacy provisions in contracts setting out requirements for compliance, including binding the service provider to certain policies and protocols of the organization, and requiring the organization to be notified in the event of a breach, which we will come to later. Also very important to consider is a cooperation clause for data subject access requests, where information will be in the possession of a service provider. So there's fairly tight time limits within which to respond to these data subject access requests. It's really important to have some sort of way of proceeding, some sort of clause in your agreements to ensure that you're being notified by your service provider right away. So it's also worth noting that if an organization is required to dispose of personal information in response to a request to do so, which is a new right being proposed under the CPPA, quite similar to GDPR, the organization is required as soon as feasible to inform any service provider to which it has transferred the information of the request and obtain confirmation from the service provider that the information has actually been disposed of. So that means that a business needs to know which entities it has transferred the personal information at issue to. You'll want to be having continually updated data mapping so you know which data is with which service provider. Under the CPPA, businesses will also likely want to include a requirement for service providers to actually be tracking and recording information disposal requests as well. So from the perspective of service providers, they'll likely want to ensure that they have appropriate logging and documentation in place to provide evidence of compliance. So this is a new right of disposal that is being proposed. And with that will come some changes in conversations that you'll need to have with service providers. So also to be considered are data residency requirements. So this is where the service provider is required to actually keep personal information in certain jurisdictions. You might be prohibited from transferring it elsewhere without prior written permission. Otherwise, accountable organizations may be offside Quebec's Law 25 and CPPA requirements that are being proposed to identify where the data is being processed. And also we'll come to in Quebec, this privacy impact assessment requirement to kind of assess when information is going prior to information being transferred outside of Quebec. So looking at security requirements, which is also a big component of this, you may want to look to ensuring that a security questionnaire is being completed as part of the due diligence exercise. This really allows you to dig into the details of what a service provider is doing with data and what processes from a technical perspective they have in place. You'll want to look at limiting service providers' ability to disclose personal information to third parties without your prior written consent. And also very important is having a security breach procedure. So in the event of a breach of security safeguard or under Law 25, a confidentiality incident, to clarify who's going to notify and report these breaches. So the timelines are quite punchy for reporting a notification. So it's really important to work this out at an early stage in your service provider agreements. So unlike PIPEDA, the CPPA actually requires service providers to, as soon as feasible, notify the controlling organization if any breach of security safeguards has occurred that involves personal information. So this language casts the net really broadly. It requires service providers to notify controlling organizations of any breach, not just a breach which creates a real risk of significant harm, which is the test that we would apply to determine whether or not to report the breach and notify individuals. Also note that the breach at the service provider doesn't need to involve the controlling organization's information. Any breach affecting any personal information held by the service provider would appear to trigger this obligation, which is a change. So the controlling organization would still have the gating mechanism of determining whether the incident actually does pose a real risk of significant harm, and to determine whether or not to report or notify on that basis. So they do still retain that control. So just to note that in Quebec, as under the CPPA, there is no real risk of significant harm threshold either. You will also want your service providers to be providing some assistance in the completion of a data transfer impact assessment. So this is required in Quebec currently for transfers of personal information outside of Quebec. So it'll be quite important to have service provider involvement and assistance in completing these assessments. So it's always good to agree that in the service provider agreement as well. Just a quick note, if you are anticipating collecting any children's personal information, that's likely to be designated as sensitive personal information. So this is implied under PIPEDA and actually expressly designated under the CPPA and Law 25. So we would advise working with service providers to determine how this express consent is going to be obtained from a parent or a guardian, which is the requirement. So you won't be able to rely on consent, implied consent, for instance, in a privacy policy. You might also want to consider working with service providers, if relevant, to age gate sites, if children's personal information is not intentionally being collected, used, or disclosed. So working with service providers to implement technical solutions on this front would be really helpful. So just a note on the CPPA as currently drafted actually contains enhanced rights of disposal with respect to children's information. So this is a new right that we're seeing, and it's worth considering whether technical solutions can be implemented to ensure that personal information from children can easily be segmented and retrieved. Okay, so the next point is on automated decision-making. So it's worth having a look at whether automated decision-making is being used to make decisions about Quebec residents. If so, Law 25 requires that any decision being made by automated decision-making is disclosed, with an individual having a right to learn more about how that decision was made. It's worth including contractual assurances and protections, for instance, representations and warranties, that the service provider won't be using information for any other purposes, including for AI purposes, and would require written permission to do so. So maintaining control over that information. So new under the CPPA would be an access right specific to automated decision-making. Under the CPPA, if an organization has used an automated decision system to make a prediction, recommendation, or decision about the individual, and an individual makes a request, the organization needs to provide the individual with an explanation of the prediction, recommendation, or decision, and an account of how that personal information was used to make that decision or prediction. So all of the above is specified. It needs to be provided in plain language. So this likely requires cooperation from any service provider who might be providing you with this technology. It's important to get the information from them that you will need, to provide this justification in plain language. The access right in respect of automated decision-making is likely to cause the most concern, given the breadth of the definition. Any technology that assists or replaces the judgment of human decision makers. So that's quite broad. It's likely that organizations will be unclear on what is or what isn't actually captured, and therefore to what requests for information they must provide an explanation and how the personal information was obtained. So it's important to have an agreement in place with service providers to ensure that the appropriate information is going to be provided in this case. So that was a whistle-stop tour through things to think about when working with your service providers. Perfect. Well, I'll hand it back to Kirsten then. Thank you so much, everyone.
Thank you, Danielle. And that was the world's fastest tour of vendor agreements. We could easily do a half-day session digging into the various aspects of that. I do want to point out for those of you that do business across Canada that the requirements and some of the obligations under the Quebec Act are sort of inconsistent with what the current PIPEDA and the pending potential CPPA is. So drafting in this the current environment is quite challenging. And if you do that, you should ask for a pay raise. Now we're going to go on to another challenging area. My colleague Luca, Senior Associate in our Toronto office, is going to be talking about de-identification and anonymization of personal information. This is an area that is much misunderstood, and it's not helpful at all that legislation tends to treat the various pieces of legislation tends to treat these things differently. Luca is the master of this. Frankly, I don't have the bandwidth to understand this, and Luca seemed to have lots of time on his hands. So he is now our expert on this, and he is going to share his thoughts with you. Luca, over to you.
Thanks, Kirsten. So like Kirsten said, this is a bit of an obtuse topic, and I'm hoping that we can, in the next half hour, kind of cover some ground that'll help us understand a few things. A, what's actually happening when we're talking about de-identification and anonymization. Aggregation is another term that gets lumped in together. These are terms that we all start to see when we're reviewing documents, reviewing contracts, entering into agreements, and involve the flow of data. These are terms that you're going to try and parse out off the top. We're going to kind of talk about the actual technology at issue. And from there, we're going to move into the risk profile associated with using personal information in this way. And I'm going to look at a few kind of recent investigations, some case law, and some material that's going to help us think through kind of what's happening here in terms of risk. The legislative developments that we've been talking about today are going to be a major part of that. And then we'll finish off by thinking about some things that we can do to mitigate those risks. So consider several use cases. Your organization, you have a tabulation, a spreadsheet of customer loan information. You take that spreadsheet, you obscure the columns containing customer information and use a unique key to do that. You then provide that scrambled table to your business analytics team, who analyzes the balance sheet and helps you understand the bottom line of your organization. Picture another scenario. You're a retailer, you engage a marketing campaign, you solicit new customers through that campaign. You collect information at an individual level consisting of name, contact information, gender, the amount that they spent on the purchase, products chosen, etc. You pool all of that purchase data into a single data set. You then obscure each customer's name and their contact information. And then you hand it over to your internal researchers, and they use that database to analyze patterns about spending habits and discover the demographic profiles that respond best to certain types of marketing. Picture another scenario, which is that you're a research institute and you have access to electronic medical records under the control of various cardiologists. You run a program that strips out patient name, age, month, date of birth from each record, and you compile data on medication dosage and lab test results after and before receiving that medication. You feed that into an algorithm that then predicts the optimal doses of medication by age and gender. So what do these initiatives all have in common? These are instances of the use of personal information in aggregate form without direct identifiers to generate value, research, intelligence, insight. These are really powerful processes, and these are processes that are becoming increasingly important in the knowledge economy. And they rely on compiling large amounts of data and getting the value out of the data that you want, and minimizing the data that you don't want. So in these examples, we don't really care that John Smith is a patient of Dr. X. What we want to understand is how John Smith responds to the medication given to him by Dr. X. So this is the context for what we're going to be talking about today. And you may be on either side of this. You may be an organization that wants to take on these kinds of initiatives and use information that you have under your control in new and powerful ways. You may be a vendor who's helping organizations get to where they want to go in terms of using this kind of data. So we're going to talk about kind of what the legal landscape looks like, where it's going, what the risks are, and how you can mitigate those risks. This is kind of the fundamental quote from the federal court, which is the kind of test for when information is identifiable, quote unquote. And as an aside, I apologize for the number of times I'm going to use the word identifiable or de-identifiable. There's just no good way to get around the repetition in this type of presentation, so apologies in advance. But this is the statement on when information or data is about an identifiable individual and thus subject to privacy law in Canada. Currently, it's when there's a serious possibility, quote unquote, that an individual could be identified through the use of that information, either alone or in combination with other information. What does that mean practically when we're talking about the use of data in this fashion, aggregate fashion, large data sets? I kind of put up here a very crude and simple way of helping us think through identifiability as a concept, and it lives on a spectrum. Now, this is grossly simplified, and in certain respects is at odds with how the law in Canada treats identifiability. But I'm hoping we can just take a minute to look at this to kind of help understand how you transition from explicitly identifiable information to information or data that has no possibility of identifying someone. So on the right, the left-hand column, you've got two types of identifiers, and then I've listed out 5 categories of data that are defined by whether they include quote unquote direct or indirect identifiers. So what are these types of identifiers? So a direct identifier is just that. It's an attribute that alone enables unique identification of an individual. So your name, the most obvious direct identifier. Something like your social insurance number might also be a direct identifier. It's assigned to you. We also have what are called indirect identifiers. So those are attributes that, when combined with other information, enable identification of an individual. So that might be your date of birth. You don't have a unique date of birth. Other people share your date of birth. But if I have your date of birth and access to some other government record, I can use that information to find out who you are. Gender is another one of these. You don't have a unique gender, people share genders, but when you combine gender with other bits of information, you can identify the individual. So those are the kind of 2 criteria by which we're going to try and kind of map out the spectrum of identifiability. So the first category here is what we call explicitly personal information. These are this is obvious personal information. Your name, address, phone number, social insurance number, copy of your government ID. It includes direct and indirect identifiers. The next is what we might call potentially identifiable. So there's no direct identifier on this data, but there are indirect identifiers. So this might be something like your license plate number. Doesn't have your name on it, doesn't tell you who you are. Have your license plate number, I can access a government registry that then pulls up the rest of your information, lets me uncover your identity. Technical data kind of also falls into this category. So that's things like cookies, IP addresses, the device ID of your mobile device. Again, not connected to you per se, but can be used in tandem with other information to find out who you are. For example, your IP address in the hands of someone who also has access to subscriber information with your ISP can be used to find out who you are. Moving along, we have the next family, which are, let's call them pseudonymous and de-identified data. And this might be a semantic distinction, but most people consider pseudonymous information to be really just a species of de-identified data. This is when pseudonymous data is when the indirect identifier is intact, but the direct identifier is kind of transformed or eliminated or scrambled. So for example, picture a database of medical records. It contains information about John Smith. He has diabetes, his blood sugar is 15.1, but the entry associated with him in the database is scrambled. It's like it's like CRKS KY113, and you need a special key to access the actual name of the patient. That's what we call pseudonymized data. And moving up from there, we have what we'll call de-identified data writ large, which can be a whole host of techniques. And I'll actually talk about some of the different techniques that are employed when we're talking about de-identification in a moment. But suffice to say, this is when you have a data set where both direct and indirect identifiers are eliminated, transformed, or obscured. And the last category is what we call anonymized, truly anonymized data, which looks a lot like its cousin de-identified data, but there's kind of a key distinction, which is about whether that data can be reversed such that you can identify an individual. And that's the crucial distinction that the law is trying to kind of get its head around when we're talking about de-identified versus anonymized data. There's a line that's being drawn, a distinction that's being drawn, a meaningful distinction between de-identified data, which can by definition be re-identified, and anonymized data, which is data for which there is no possibility of re-identification. It's irreversible obscuring of both direct and indirect identifiers. The kind of crucial thing here to understand is that to take it forward is that de-identified data can necessarily be re-identified. De-identified data means it's in its current state obscured, but can always be re-identified versus anonymized data. And there's been a few high-profile instances where researchers armed with their wits and the right technology have been able to re-identify large publicly available data sets. So in terms of where the law is going with this, what we're seeing is that there's the kind of fuzzy border between these de-identified forms of data and the identifiable ones are being kind of consolidated. The law is trying to bring under its fold all forms of data that can be re-identified and carving out data for which there's no possibility of re-identification. So I'd mentioned a moment ago that de-identification can take a number of forms, and I think it's helpful just to go over some of the techniques and the terminology, because these become germane when you actually start digging into this and trying to understand what's going on under the hood. And I will add, of course, I welcome all questions. I will try and address them as best I can if I'm able to on the fly. If not, we will get back to you after the session. So these are kind of a series of de-identification techniques in kind of ascending order of complexity. So the first one is suppression. The most basic one, you basically have a data set, you take out a bunch of the data prior to sharing it or using it, so that the identifiers are removed. And this is like, for example, if you have a survey that you've done and you've, asking people about things like gender identity or ethnic identification, and you have a data set that, even though you don't have direct identifiers, like you haven't asked people for their names, if you disseminated the entire data set, you would kind of know who responded based on the fact that there's only a certain number of people of a certain sexual orientation or ethnicity in a particular office space. So this is, you take out kind of the questions that would, the responses to the questions that would enable you to identify people, and then share the rest of it. Blurring is kind of the next step up, which is when you reduce the precision of data by combining one or more elements. So this includes aggregation, which is you combine individual data with data of other individuals, and you kind of pool it all together such that you're disguising the attributes of a single subject. So, you're reporting group averages instead of individual values. Generalization is related to that, and that is when you take collect or report or use values in a given range. So, for example, age ranges instead of specific dates of birth. That's a form of generalization. Using rounded numbers instead of exact values is another type. So we're giving, back to my lab results example, we use ranges of lab results, not specific lab results. That's generalization. And finally, we've got masking. So masking is when you actually are kind of replacing one data element with another, either random or made up value in the data set. So we've got techniques like encryption or scrambling, where data is scrambled and then you need some kind of technological key, encryption key, to access the data. So unless you hold this key, all you're going to see in a data set is a table with patient names that are totally scrambled, and you need to use this encryption key to de-encrypt the data and get the actual underlying identifiers. We've also got what's called noise and differential privacy, which is essentially an algorithmic technique that's kind of on the bleeding edge of this, which is a statistical technique that introduces noise into a data set while preserving its utility. So essentially, there's an algorithm that introduces random noise into a data set, but is still able to kind of read the useful data from within that, although on the surface, the data is noisy and obscured. Okay. So that's kind of the lay of the land in terms of what we're actually talking about technically here. The question is, how does this all play out in the realm of privacy law? And what does it all mean when we get down to the legal landscape here? So kind of current state is where I'll start, and I'm going to preface this by saying I'm only going to be talking about the private sector for the most part in terms of the actual statutes at play. De-identification, as you might imagine, is a kind of a massive piece of our health information space. We, as a country, value the use of health information for research purposes, and there's a whole kind of regime, at the provincial level relating to the use of health information. So I'm not going to have time to talk about that today, unfortunately. So I'm going to be focusing mainly on the private sector. So PIPEDA, which is our current private sector regime in most of the country, and doesn't actually talk about de-identified or anonymized information. Those are foreign concepts. They don't come up in the legislation at all. So it's been left to the courts and the Office of the Privacy Commissioner to kind of divine how to address de-identified or anonymized information under that regime. So the OPC has said that personal information that's been de-identified does not constitute anonymous information if there's a serious possibility that someone could link the de-identified data back to an identifiable individual. It's a mouthful, but recall our chart here. This is that borderline between reversibility and the possibility of re-identification. The question then is, what is the threshold? What kind of risk of re-identification does there need to be for it to be quote unquote de-identified data? Now, the word serious possibility unto itself is not that helpful. I'm going to talk about a case that was decided under PIPEDA later on to kind of illustrate what the regulators, how they might think through questions of sufficiency of de-identification if it comes before them. But suffice to say that currently we're in a kind of open-ended space where we have this kind of tautology about serious possibility, and it's open to the regulators to address it on a kind of case-by-case basis. You know, for example, a very simple example is that in 2009, the OPC found that a psychologist's peer review notes that they were sharing with their colleagues in terms of a case study were subject to an access request under PIPEDA, because while they couldn't identify the individual by name, they included enough detail about her such that she could be identified. So they then said, well, for that reason, this is personal information. It's within the scope of the act and is subject to an access request. That's a fairly basic example, but kind of illustrates the thinking to date. In terms of where we're going next, you've heard about the CPPA thus far. You heard about Bill C-27, which is working its way through the legislative process. And in its current form, Bill C-27 would actually contemplate so-called de-identified and anonymized information. So really, the way I read this is that this is the legislature trying to codify this distinction between de-identified and anonymized data based on the property of reversibility. So you can see the definitions here. De-identify is to modify such that an individual cannot be directly identified from it. Okay. Though a risk of the individual being identified remains. There's that reversibility property. Versus anonymization, which is when you irreversibly and permanently modify personal information in accordance with generally accepted best practices, question mark about what that means, to ensure that no individual can be identified from the information, whether directly or indirectly by any means. So there's this idea of permanence when we're talking about anonymized information. So really what you see here happening is that the government is carving out quote unquote de-identified information as a kind of species or form of personal information to which, as I'll go through in a moment, certain exemptions or additional obligations will apply. They're treating it as this kind of type of personal information that is special, but it's a form of personal information nonetheless because there's that possibility of re-identification. And the standard that they're currently riding on is that there is a risk remaining of re-identification. Now, this is importantly, you're going to want to note that this, as currently drafted, theoretically lowers the threshold from that serious possibility that we were looking at before. So if this goes forward as currently drafted, my read is that it would import a lower standard for the risk of re-identification, and thus would make everyone's efforts to actually de-identify information in a legitimate sense more onerous. In terms of what you can do with de-identified data under the Act, so organizations will be able to use de-identified data in a number of ways. One of them is that they're going to be able to use it without knowledge or consent, normally requirements under privacy law, to de-identify the information at first instance. So you don't need knowledge or consent to actually do the de-identification in the first place. And then you get to use that information for quote unquote internal research, analysis, and development purposes. So this is going to be of much interest to organizations moving forward. You know, remains to be seen what the scope of this looks like moving forward, but to my mind, this is drafted broadly enough that it would constitute most of the kind of insight and business intelligence functions that we kind of talked about at the beginning of the presentation and which you might be interested in undertaking. But put a pin in that because this might be subject to revision. future guidance, and of course, investigations. There's a couple other things happening with the CPPA and de-identified data. You get to use it, but you have to apply technical administrative measures that are proportionate to the purpose for which the information is de-identified and the sensitivity of personal information. So it's a bit unclear what this is really doing, but it appears what they're intending here is that you're actually required to interrogate the method by which you're de-identifying the data. And it's kind of like a balancing exercise where you have to consider the uses for the de-identified data and the sensitivity of the underlying PI, and apply measures to de-identify it in the first place that are commensurate with that sensitivity and the purpose. So for example, something that has like a public facing purpose would theoretically attract a higher standard. So it's probably best kind of thought of as a risk of harm analysis, and probably a little easier to understand if we frame it that way, which is that, are the measures applied proportionate to the harms that could result if the information were to be re-identified? And it's not on the slide, but there's also an outright prohibition on re-identification. So once the information is de-identified, you don't get to then use it for a purpose that would identify an individual. It's kind of a one-way street. Not to be outdone, of course, we have Quebec, which has entered the fray with Law 25, which you've also heard a lot about today. And it's mercifully largely congruent with what they're doing at the federal level. And here you'll see the language of the statute here, which is personal information initially collected for one purpose may be used within an organization. We'll come back to that in a sec, without consent, for study, research, or the production of statistics if the information is de-identified. Okay, so that, to my mind, reads similar to the CPPA language. It would, to my mind, encompass that kind of business intelligence functionality. Now, notice that they've only said here that you can use de-identified data without consent. They didn't include notice or knowledge here. So it's an open question as to whether you actually need to provide notice of your use of de-identified data under Law 25. It's not on its face. The legislation would suggest that you may have to actually provide notice, even though you don't need consent. But this is something we're monitoring, of course, in terms of any guidance. In terms of what de-identified data looks like, it's circular if it no longer allows the person concerned to be directly identified. And this is in contrast to anonymized data, which is data where it's at all times reasonable to expect that in the circumstances that it irreversibly no longer allows the person to be identified directly or indirectly. So again, you see that the legislature is drawing this distinction between this kind of irreversible process, which they're calling anonymization, and de-identification, which is reversible. So that's kind of an outline of the legislation itself. And at the end of the day, it's like, what are the risks associated with that? So you get to use de-identified data for all these purposes. There's these exceptions. You get to use it for various purposes. Great, you get to run data, generate insights. Perfect. What are the risks associated with doing it? Doing that. So I think the important thing to consider here is that we're moving towards a world where the use of de-identified information, short of truly anonymized information, is increasingly falling under the purview of privacy law. Now, there's some nuance in terms of the language of the legislation. So obviously the CPPA has this one standard where it said there remains a risk. The Quebec legislation defines it a little differently. It says information is de-identified if it no longer allows the person concerned to be directly identified. So that's a bit of a wrinkle in terms of how we define it. But essentially, we're trying to draw this distinction where we say we have anonymized data that's kind of outside the scope. Then we have this whole universe called de-identified data, and you get to use that de-identified data in special ways, but you have to treat it specifically. Now, and the risks associated with the use of this information are exacerbated, in my view, by the fact that quite often there's third parties involved in the whole process, and organizations are relying on third parties to de-identified data. So by way of a case study in Quebec, there's a recent decision involving the use of a technological tool by a school board, and the investigation came before the CAI, which, as you heard today, is Quebec's regulator. The tool was developed by a third-party vendor, and it worked as follows. That school board provided the vendor with temporary access to a database consisting of around 300 types of de-identified data. So student data, admission registration documents, report cards, school information sheets, etc. The vendor then used algorithmic technology to analyze the data and generate a set of predictive indicators of dropout risk for grade 6 students. And then they provided the school board with a list consisting of student record numbers, along with predicted dropout risk level and factors associated with that number as determined by the algorithm. Now, to identify the specific students at risk, the school board would then have been required to link the list with its own records using a student record number. So that was the linkage point. And when this investigation went before the CAI had not yet done so. So in this case, the school board had removed around 80 types of data from the record before providing it to the vendor. That included student names, home addresses, email addresses, student portal usernames, etc., before granting the vendor access. And the CAI still found that it considered the resulting de-identified data to be personal information under the Public Sector Act. And in doing so, the CAI relied on the amended version of the Public Sector Act, which is amended by Law 25, which provides that information concerning a natural person is anonymized if it irreversibly no longer allows the person to be identified directly or indirectly. And so the CAI took the position ultimately that the data here, which could be re-identified, ultimately remain personal information. And then from there, had a whole set of reasons about what needed to happen in terms of consent, notice on the basis of the fact that it considered that information to be ultimately identifiable. So again, these are kind of the kind of risks that we kind of see attracting to this process. Given that there's kind of guardrails around the use of personal information, we have risks around the unauthorized use or disclosure, contrary to legislation. In the case of Quebec, it's an open question about whether we need to provide notice. So are you providing notice of the purposes for the collection and the subsequent de-identification? If we're talking about large de-identified data sets, those are obviously at risk of being subject to a data breach. And if they're considered personal information, then that obviously enhances the potential liability, the attendant liability. And then we also have, in the case of the CPPA, the kind of violation of the prohibition against re-identification itself. So a lot of this is going to come down to the details of how you actually deploy the kind of technical elements and the contractual protections around your de-identification of data. So an ancillary point to a recent joint investigation of all of the privacy commissioners in June of last year dealt with a franchisor deploying an app provided by a vendor that collected granular location data. So the de-identification was not at the core of the complaint, but the commissioners addressed it nonetheless. And they looked at the service agreement and authorizing the vendor to use the data. And it read that the vendor could use the data to improve and enhance the services and for other development, diagnostic, and corrective purposes in connection with the services and other company offerings, and that the vendor could disclose such data solely in aggregate or other de-identified form in connection with its business. So the commissioners found this language to be vague and permissive, in part based on the fact that there's some ambiguity in the defined terms. It wasn't clear what the service is, who the companies were, unfortunate sloppy drafting. And they concluded that on this basis, there's enough permissiveness in this provision that the vendor could have used the information in de-identified form in connection with its own business. Now, setting aside the issue with the commissioner finding fault on the basis of what could happen in the future, which is an unfortunate tendency of theirs that we're seeing, the key takeaway here is that the language in a contract that involves de-identification of data, sharing of data between an accountable organization and service provider that is not precise and clear about who's doing what with what information attracts risk. So here, this company came under an investigation as if it's service provider, and there's an adverse finding based on the fact that it wasn't really clear who could do what with what data. And indeed, something I see a lot in my practice is the kind of conflation of these terms. So we see aggregate, de-identified, and anonymized used interchangeably. And I hope it's becoming clear that those are not interchangeable terms within the meaning of the law, privacy law moving forward. They're meaningfully different. So if we mean the use of anonymized data, we have to say it and we have to understand what that actually means. And if we're talking about the use of de-identified data, well, we have to understand what that means and understand that the latter is arguably within the purview of privacy law. So we can't just hand wave away the application of privacy law by kind of conflating these different terms all together in a jumble. In terms of mitigating risks on a technical level, there's a helpful decision that came up under the Privacy Act, and it related to the collection of mobility data by the Public Health Agency of Canada during the COVID-19 pandemic. Now, this was a complaint under the public sector legislation, the Privacy Act. However, as the definition of personal information and identifiability in contrast to anonymized information is the same, it's applicable to the current state of play in the private sector, and kind of illustrates what a regulator is looking for in terms of assurances around re-identification. Now, this is going to be relevant, like these kinds of considerations are going to be irrelevant moving forward under the CPPA, because remember, the actual process by which you de-identify information is going to be a factor, right? There's that safeguard provision that we looked at. And just kind of, keeping an eye on the time here, in a nutshell, the program involved the provision of location data by a telecommunications mobile provider to the Public Health Agency of Canada, which I'll just call Public Health. The issue is whether the data coming into the control of public health was quote unquote personal, such that the Privacy Act applied, which would then trigger off a whole set of obligations around whether it was justified in collecting and using, disclosing data, etc. So the data at issue was in the form of, in two forms. One was in the form of cell tower data, which included a host of data elements, such as timestamps, device country, area code, network cell identifier, time the device was used, time it was last seen on that cell tower, the duration is connected to that cell tower, and the approximate geographic coordinates of the cell tower. And then the geolocation data, which actually flowed from the devices themselves, was collected via mobile apps and was limited to location data. So the OPC considered, the OPC accepted that this was all de-identified data, but was really concerned more about the possibility of re-identification, which would, of course, like I just said, trigger the application of privacy law. So I looked at all the safeguards that were used in this scheme, and it ultimately found that the safeguards employed were sufficient such that there wasn't a quote unquote serious possibility of re-identification. Recall that serious possibility is the current standard. This is going to change under the CPPA moving forward, but that's what the threshold that was considered in this particular decision. And just in terms of the kind of technical safeguards that were employed that they approved, they looked at things like, for example, on the cell tower data, any direct identifier was removed or irreversibly encrypted such that it couldn't be de-encrypted, right? So those are the direct identifiers. Raw data was siloed, so the data was actually set up in what they call enclaves, and the only way it could be accessed was by running queries on the data set and generating aggregate results. There's no access to the actual raw data by public health. They looked favorably on the type of aggregation used. So information, data couldn't be traced to the individual user. It can only be available in chunks consisting of at least 20 devices collected over the span of 24 hours, and also sorted by a kind of looser geographic area, which was census areas. There was an option to sort by, for example, postcodes, which is a more granular sorting. So the commissioner looked favorably upon the fact that they use census areas. And of course, there was contractual protections that did things like limit the recipients of the data and the purposes for its use, and actually required contractually participants to only access data in the aggregate. So as we're kind of thinking through arrangements by which you're using de-identified data, these are the kinds of factors that we need to start considering when we're employing de-identification technology. Now, we're sharing these slides, so I've included links to a few kind of helpful standards that inform the kind of technical side of de-identification. There's one fresh off the press by NIST. There's also an ISO IEC standard, which might be of interest to those who are engaging in vendors. This might be something you might be asking your vendors about, whether they're compliant with this kind of ISO standard. And then there's a 2016 guideline from the IPC, which is guidelines on structured data. So I included the links to those as well. Now, just conscious of the time, I think there's contractual safeguards that you need to think about, and Danielle has gone over those, but I reiterate some of those here. So for example, is aggregation and anonymization de-identification actually permitted? Consider whether de-identification for secondary purposes by, for example, a vendor for its own purposes is even permitted at this point. This would be different from true anonymization. If the service provider wants to anonymize the data and then take it off, that might be a different story. What are the purposes that they're allowed to do that for? What are the access controls? Who has access to de-identified data? Consider your kind of basic reps and warranties with respect to re-identification or other misuse. Fold those into other kind of reps and warranties. Consider indemnities that properly address the misuse of de-identified data. Again, depending on how you're defining all these terms in your service agreements, we don't want misuse of quote unquote de-identified data to escape an otherwise favorable indemnity clause, because that only spoke to quote unquote personal information as defined in the agreement. So these are some of the things to kind of keep an eye on and consider moving forward.
Thank you very much, Luca, and thanks for the questions. There were a number in the Q&A, and I see they're very thoughtful questions. This is a very dense topic, but increasingly it's a more and more important topic, as the premise for a lot of agreements is really the ability to use aggregate, de-identified, and or anonymous data. We may actually, there's sufficient interest in this, hold another webinar on this topic specifically.